Hi all, today topic is comparison of a private trust with a public trust. Introduction. The Indian Trust Act 1882 governs the private trusts established in India. This act is applicable to the whole India. Anyone can create trust in India, but it doesn't apply for any of the boards or mutual relations of the members of undivided Hindu family, which determined by any customary or personal laws on religious or any charitable endowments. And a trust is a particular kind of fiduciary relationship established between trusted and the trustee. Public trusts in India are usually governed by state-specific legislation, such as example like Maharashtra Public Trust Act and Andhra Pradesh Public Trust Act and Telangana Public Trust Act, etc. A trust can be established to save time, stop pointless conflicts, lessen paperwork, and aid in the prudent administration of the truster's assets. What is a trust? Trust is defined in Section 3 of the Indian Trust Act 1882 as it is not defined as an obligation annexed to the ownership of property arising out of a conference which is reposed in and accepted by the owner or declared and accepted by him for the benefit of another or another and the owner. In other words, we says the transfer of property by one person means the settler to another, which is the trustee, who manages the property for the benefit of someone else, means beneficiary. Here, the settler must legally transfer ownership of the assets to the trustee of his trust. In Indian trust is the second most popular form of registration in the world. Who can form a trust? As according to the Section 7 of Indian Trust Act 1882, a trust may be created by any of the following persons like by or on behalf of minor with the permission of a principal civil court of original jurisdiction. And according to Section 11 of Indian Contract Act 1872, every person committed to a contract, as in associate of persons, in simply AOP, and Hindu Undivided Family HUF, and or by trust by a woman or any other company can form a trust. How to form a trust? One can make a trust with the help of a legal firm or a bank for which a trust document has been drafted, and this should be state the type of trust. It would be very reasonable. It should clearly state the name of the settler, the trustees and their beneficiaries, as well as a list of all the assets the trust will be hold. Apply for a permanent account number for the trust and open a bank account for it as it is a separate entity. The trust may or may not be registered, and registration is required only if an immovable property is transmitted to the trust. And who can become a trustee? As per Section 10 of Indian Trustees Act, any person who is capable of holding property may be a trustee, except to the condition of discretion of trust. In that case, he cannot execute it unless he is competent to the contract. Types of trust. Generally, there are two types of trust in India: private trust and public trust. While coming to private trust, they are all governed by Indian Trust Act 1882. In public trusts are divided into two categories. They are charitable trust and religious trust. As some of the statutes for the enforcement of public trusts in India, they are the Charitable and Religious Trust Act 1920, the Religious Endowments Act 1863, the Charitable Endowments Act 1890, and the Mumbai Public Trust Act 1950, etc. Moreover, in recent times, trust can also be used as a vehicle for investments such as mutual funds and venture capital funds. These trusts are governed by Securities and Exchange Board of India, which is simply known as SEBI. Difference between public trust and private trust. A public trust is a trust for a public entity. It is a constructive trust meant for religious and charitable purposes. However, the entity or society has to be registered society entity order be listed as a beneficiary. While coming to private trust is where the beneficiaries are defined and specific individuals. Means you can name anyone to be your wish trustee or the trust. The beneficiaries are the often individuals of the people. It can be your family and relatives, or it can be a very close friend. In a public trust, there is no specific purpose and are of any individuals to contribute entities. Meaning to say that when an individual passes away, none of their assets or money will be go to any entities unless specifically stated in their will and legal documents. While coming to a private trust, here, if private trust, if a person passes away, the distribution of act pushes the fact unto that this is a nest of kin, gets their money, assets, and their properties. This is only when the deceased leaves no will behind. There are shared portions that get shared between the family members. Public trusts often are made of for the purpose to benefit the public as a whole. For example, if you are a member of religious organization or any society and someone passes away and listed your religious institution as their beneficiary, then that means whatever money and assets that the deceased has given to your religious institution will not just benefit the institution itself but also anyone and everyone else who are members of the institution. While in private trust, as the name suggests, private trusts are for the benefit of private individuals. If the will states certain members related will receive the money or assets, then the individual will receive accordingly. However, if there is no will, which means there will be no trustees, then the distribution of act will apply in this situation. An executor will take over the role of a trustee and help with the distribution accordingly. Public trust is governed by laws which are enacted by the state itself but established separately. Where coming to the private trust is governed by the only Indian Trust Act 1882. When public trust is very mandatory for registration for immovable property, which is desirable for movable property for tax exemption. While coming to private trust, it is registration is not crucial, not mandatory, even for immovable properties also. While private trusts are subject to different tax rules than the public trusts. Private trusts are generally subject to income tax on their earnings, while public trusts may be exempt from certain taxes also. Conclusion. Finally, I conclude that trust is a concept which is generally features around the author. Means the trustee and the beneficiary or beneficiaries having rights and obligations assigned to each of them separately. There are many advantages of trust like protection of wealth, taxation, welfare of family members, protection of from insolvency, helps in succession of property, and which is more to the Trustee Act. If the trust is formed with all these requirements legal procedure, then it is for beneficial for each of the organ of a trust in the trusteeship. Thanking you all.